Welcome to Soundbites for Q4 2022. The last quarter of 2022 saw a number of developments in legislation and compliance for lawyers around economic crime. These raise the potential for financial and, in some cases, criminal penalties, as well as potential reputational risks for law firms. In the last Soundbites, we mentioned the war in Ukraine and its economic impacts. The war has also had legal consequences. On 30th September, the government announced the latest in a series of sanctions since the start of the war in February on transactional legal advisory services for certain commercial activity. The situation in Ukraine and the resumption of what is effectively a Cold War with Russia mean that sanctions are going to be an issue for the foreseeable future. Sanctions may seem a world away from the firm's practice. However, the SRA's sanctions guidance of 28th November 2022 is addressed to all SRA-regulated firms, solicitors, registered European lawyers, and registered foreign lawyers. This is because the sanctions regime applies to all firms, and the possible consequences of acting without authority for sanctioned individuals, referred to as designated individuals, can be serious: fines and imprisonment. The sanctions regime is complex and subject to frequent changes. To manage the risks, follow the SRA's guidance. Some key issues. Make use of resources to keep up to date. There are government websites detailing legislation and designated individuals, including a screening platform provided by the Office of Financial Sanctions Implementation. Review your due diligence processes for taking on clients. Like AML, establishing their identity is a key part of complying with your sanctions obligations. Unlike AML, with its risk-based approach, breach of sanctions is strict liability. And consider checking counterparties for evidence of designated individuals. From an insurance perspective, claims made by designated individuals may be subject to sanctions legislation and insurers prevented from making payment. A further attempt to tackle economic crime is the Economic Crime Transparency and Enforcement Act. This came into force in 2022 and requires overseas entities which own land in England and Wales to register details of their beneficial ownership at Companies House by the end of January. Some issues here. Solicitors can conduct the verification process to confirm beneficial ownership, but are not obliged to do so. There are potential fines and imprisonment if the application to Companies House is based on wrong information without just cause. Again, unlike AML, there's no leeway in taking a risk-based approach for failing to register the correct beneficial owners. Failure to register beneficial ownership details at Companies House, and ultimately the land registry, prevents any dealing with the land. So potential for negligence claims if there are delays in the verification and registration processes. For further guidance, see the Law Society's note of 29th July. So those are some of the current issues we're seeing for law firms around economic crime and some potential controls to manage the risks.